This courtroom showdown is about more than unpaid rent, it's about stolen belongings, broken promises, and a tenant who says she was locked out while moving her life. In today's case, we follow a woman who claims her landlord changed the locks mid-move, leaving her without essential belongings, even a firearm. Meanwhile, the property manager pushes back hard, arguing she signed a new lease and had more than enough time to retrieve her items. But what's really at stake here? Is this a case of eviction, miscommunication, or something far more negligent? And when the judge hears both sides, her patience wears thin. Stick around, because it's not just about who's right, it's about who the court believes.
The court sent it to me. It doesn't say anything. There's no attachment. I'm not sure what the defenses are. And frankly, Your Honor, I don't know if you recall, but this particular resident was in another unit. We generously waived her entire balance because she had repair issues. We moved her into a new unit, and now she hasn't paid any rent.
I was locked out in the middle of moving.
Sorry.
I was locked out in the middle of moving, and they didn't help me with like what we agreed upon.
You were locked out and they didn't help you. What do you mean by that?
So remember how we were talking about how I couldn't afford a moving truck and that they will figure out something for me.
Right.
They locked me out in the middle of moving. And when we got access, which was end of May, a lot of my stuff was
a firearm. That immediately elevates the stakes. Losing personal items during a move is one thing, but a missing gun raises serious security concerns. Here's the legal kicker. If the landlord changed the locks before the tenant could retrieve her belongings, and there's no formal notice or agreement, that could potentially expose them to liability. But was this a clean cutoff or a misunderstanding? What would you do if you returned to find your apartment locked and your valuables gone? Let us know in the comments.
In essence, you're saying they changed the locks before you got all your stuff out.
I don't know what to do at this point.
Your Honor, if I can add, I would respond, but I'd rather have Amy respond because she has direct knowledge of what happened, because I don't believe that's our position. And I also don't believe it's relevant to this case, but that's a separate issue. I think it's worth responding to.
Your Honor, that's absolutely not factual. She signed a whole new lease, and I don't think I don't think Ms. Lutkoff or anyone would volunteer us to pay for a moving truck or use my maintenance guys to move her belongings, which is what Ms. Vanek seems to be under the impression that we offered her in court. She was given plenty of opportunity. In fact, there was a lot of grace given here to remove her.
Here's where things start to twist. The landlord says the tenant had multiple chances to remove her belongings, even showing grace. But notice the shift. The excuses, like lack of childcare or work, aren't just emotional context. They're building a narrative that she was given time and didn't use it. Legally, if the tenant was aware of the deadline and failed to act, it may weaken her claims. But is the property manager being honest about what they offered, or just trying to cover tracks?
Well, was there stuff in there?
Yes, my stuff was in there. And I have the
Boxes,
keys right now.
I believe.
I have the keys.
So what?
The keys
I
are
mean,
in my back.
I can't say whether she kept a set of keys or not, Your Honor, but what I do know is that way later after the fact, after she's been in this other apartment for quite some time, she's bringing up issues of stuff that she wanted out of the old apartment. And at that time, I had already started a trash out, Your Honor. I mean, she signed a whole nother lease.
Your Honor, I think there was an issue.
I understand she signed a whole nother lease, but I'm just trying to figure out what period in time are we talking about?
I have a timeline. So
Your Honor, I'm going to just state for the record here that factually, just from a legal perspective, if she wants to pursue, she certainly can file an action for damages if she feels that her property has been damaged on another unit, but we're in court on this unit. And so I don't believe it's relevant.
Yeah, but this unit, Ms. Lutkoff, that's disingenuous because this unit only comes about because of the issues that were in the other unit. So to try to separate them out doesn't make much sense.
Well, I think it does, Your Honor, because she didn't remove her belongings, but obviously this is your court.
The judge is done playing referee. Notice the tone shift here. When a judge says, "We're doing it my way," it's a signal that patience is running thin and facts need clarity. Judges want timelines, not emotions. So far, both sides have conflicting versions of what happened, but now it's time to focus on specifics. Was there really an agreement to help with moving? Is that enforceable? It depends on whether it was in writing, a sworn court statement, or just verbal goodwill.
Well, but that's fine. You want to consolidate it, I don't have an issue with that. We can provide you documentation
Well,
as
you
to
can
what
have an
happened.
issue with anything. All I'm trying to do is get to the bottom of this. Bottom line. That's all I want to know. And I want to know where I'm going to take this case. So she can have her objections, you can have your objections. We're going to do it my way. Go ahead, man.
All right. So the reason why we're here is because I feel like I can't trust their maintenance people because my stuff was stolen. I don't want anyone coming into my apartment.
Ma'am, you were at the point of a timeline.
Yeah. So the timeline is I think we did our court date like April 26th, I think. And that's when we dismissed the case, which honestly, I wish we had set things and whatever. And then that next week or that Friday or whatever they had to finish with the apartment, I think we grabbed the keys like that Friday. So then we started that weekend because I was working 2 to 10:30. So we were putting the kids to bed and then we were getting the stuff. Plus, like I said.
Okay, fine.
Couldn't move it.
So how much time passed between the time that you got the keys to the new place?
It was like a week and 3 days. And
so
then we
10 days passed.
And we lost access for 3 weeks. We didn't get this.
Oh, ma'am, stop. You had after you moved into the other apartment, you had access for 10 days.
Basically, yeah.
And you couldn't get all of your stuff out in 10 days.
Boom. The judge hits with a reality check. 10 days is a generous window to move out, especially when you've signed a new lease. From a legal standpoint, tenants are usually given a limited grace period, and once they surrender keys or sign for another unit, landlords are within their rights to secure the property. But this leads to a moral question. Should more time have been granted, especially if a firearm and children's items were involved? Was this just policy or punishment?
I'll be honest with you. If you're telling me you made it sound initially like they locked you out, and that's all I was trying to get to the bottom of. They didn't do that. It seems like, and by what you're telling me, you get the other unit, you got 10 days. And you don't get all your property out in 10 days.
Well, technically, we didn't even have 10 days. They only gave us a week, but.
Okay, and that's even my point. Yeah. My point is 10 days would be extraordinary grace to get your stuff out. Yeah. A week, maybe about normal. That you move from one unit to the next unit. Maybe
what about the previous agreement that some help was going to happen?
Ma'am, I don't recall that being the issue.
Can we look over the transcripts, please?
The transcripts of what? If you want to order transcripts, you can.
I tried. I haven't gotten a response.
Your Honor, I have not received a request for any.
It was a month and a half ago, granted. Sorry.
No, ma'am. You made a request for transcripts to my staff?
Yes, I did. I called and then they told me to email her.
Email who?
Whoever, I don't remember the name.
Well, you're going to have to show me that email because I'm going to be honest with you. If you're telling me my staff did not respond to you or did not address that.
Okay, give me 1 second.
Sure. Ma'am, while you're looking for that, who was supposed to help you move?
I'm not sure. Apparently, I mean, it said that they will figure something out because I literally said I could not afford a moving truck.
Okay. So you go over to this new unit and you have not paid any rent in that new unit. And your justification for not paying rent in the new unit.
Here we go. Now we understand why she stopped paying rent. Her argument, why should I pay for a place where I feel violated and unsafe? But legally, rent obligation doesn't disappear because of past grievances, especially if the new unit is separate. This moment exposes the emotional core of the case. She feels betrayed and disregarded. But courts operate on facts, not feelings. So the question becomes, did she prove the theft? And was it truly the landlord's fault?
Except they did because we made an
You know
agreement.
what? Here's what we're going to do. We're going to set this for a trial. We're going to set this for a trial on an expedited basis. Because did you find that email to my staff? Because I don't believe that you're telling me the truth. Because, ma'am, I'm going to tell you what. When somebody tells me my staff didn't respond,
I did call up here. I will say that.
but you said you sent an email.
Yes, unless it didn't. Oh, it didn't. Well, I have it on here, but I didn't send it apparently.
Well, I'm not going to make you apologize to my staff for trying to say they didn't
No,
respond. No, ma'am, I'm just going to tell you right now. Here's how I work. And my staff knows this. If somebody wants something from them and they're supposed to provide it, they provide it. If you come up in here.
Oh wow, that's the judge, snapping back hard. False accusations against courtroom staff are a fast track to losing credibility. Judges fiercely protect their team, and accusing staff of negligence without evidence. That's a huge misstep. From a viewer's perspective, this moment flips the tension. No longer is the tenant just under scrutiny for her claims, now her own honesty is in question. What do you think? Was this an honest mistake or a failed tactic to gain sympathy?
Tuesday
I can't.
of this month?
Could we possibly set it for August?
No. You have, ma'am, I'm not going to delay this out. You paid no rent.
Okay, but I have a class on Tuesday.
Ma'am, I get, we all have different things on Tuesdays. We all have different things, different times. I'm going to set it for trial. You've not paid them any rent. You're claiming that they stole your stuff. You're claiming that they didn't help you. Well, I'm going to get to the bottom of it, if that's what it is. So I'm going to set non-jury trial in this matter.
Are we
For
like,
July 23rd.
so does that mean like jury and stuff?
No, ma'am. No jury was requested. July 23rd, 2024. That will be at 9 a.m. That will be in person.
This courtroom drama gave us it all. Disputed timelines, missing property, and a heated clash between tenant rights and landlord obligations. The judge has set a non-jury trial for July 23rd, where the facts, not just feelings, will finally be tested under legal scrutiny. Until then, we're left wondering, was the tenant truly locked out and wronged, or did she miss multiple chances to make things right? Let us know your thoughts in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and subscribe for more jaw-dropping courtroom breakdowns only here on your channel name.